Your lawsuit has gone on for what seems like forever. You want it to end. It's been going on for years and years now. When will it end? Would you like to know the answer? Come join me for a moment as I share with you the answer to that question. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. It's really windy where I am right now, so I have a few moments to share this with you as I'm waiting for my wife on the beach. So let me answer the question. When will it end? It will end when it ends. Now that's not a good answer, to be honest. It's really not a good answer. Why not? Because each case is different. Each case is individual. The case could end in 2 years. The case could end in 3 years. There could be delays associated with your case for many different reasons that could make it happen and make it continue on for more than 3 years. There could be many reasons why your case would get delayed and many reasons why it doesn't end as quickly as you believe it should. Now, I know that when you bring a lawsuit, you want this to be over as quickly as possible. You want your attorney to expedite this. You want your attorney to go ahead and get this fast-tracked. And that's perfectly reasonable. The problem is that there's a process that goes on. Just like in a medical malpractice case when you went to your attorney in New York, and now it took them months to get all of your medical records and have it evaluated by a medical expert. Why did it take months? Because it takes a considerable amount of time to get copies of your records, and then it takes a great deal of time to hire a medical expert who's qualified to review these records, and then once we have an opinion, now we have the green light to go ahead and start a case on your behalf. But after that, why shouldn't it move quickly? Well, because once the lawsuit gets started, now the defense attorneys who are assigned to represent the various doctors and hospital staff, now they have to go through that same investigation process that I just mentioned that we did initially, where now they have to go ahead and get copies of your records. They get copies directly from the source after we give them permission slips to do that. And then they have to have their own experts review your records. Okay, after that's done, you would think, wait a second, now this should be expedited. The defense should realize very quickly that you have a valid case and you have very substantial injuries. We would like to think so, but that's not really the case. What typically will happen is the defense will say, listen, we want to question you in a pretrial process called the deposition, under oath. We want to know from you exactly what you believe occurred. We want to learn about conversations you had with various doctors and hospital staff. And we want to know what limitations and problems and disabilities you have because of whatever we did wrong. So now they will want to go ahead and question you in a pretrial deposition. And after your deposition, you're thinking, okay, now they have all this information, this should be quickly resolved, right? Well, not exactly. Many times they are refusing to acknowledge they did anything wrong. So they challenge us basically to go ahead and question their doctors in the same type of pretrial process known as a deposition. And now we have to go ahead and question each one of the parties that you have named in your lawsuit. This takes a great deal of time because we have to get our schedules correct. We have to wait for the doctor to be available or to be made available. And once those depositions are done, which can take many, many months, if not years, depending upon how many different people you have sued, now you're thinking, okay, now's the right time. This is going to be expedited at this point. You have all the depositions, and now you're going to be disappointed. Now, why do I say that? Because you think your case is now ready to be settled, and you think the case should be settled, and you think the defense should immediately recognize that you have the best case in the world, and this case definitely should be settled. And you might be 100% right. However, the defense turns around and says, you know what? Now we know all the details from Oginski's client. Now we know the details from our doctors and hospital staff, and we believe we did nothing wrong. So now we are going to ask the judge to throw your case out before you ever get to trial. That's known as a motion for summary judgment. And now I have to go ahead and prepare opposition, spend hundreds and hundreds of hours of my time opposing this request, and it's a very involved process. And then we have to hope that the judge agrees with us that your case should not be dismissed. If the judge agrees with the defense, guess what? He will dismiss your case, and that's it. Your case is over. And your only opportunity may be to go ahead and appeal, if possible. So now you keep asking, when is it going to end? I don't understand. Well, let's assume that you have won the motion to dismiss, meaning that your case is not being dismissed. And you turn around and say, okay, great, now they're going to go ahead and settle this case quickly. Well, not exactly, because now your case sits on the trial calendar waiting for it to be called for a pre-trial settlement conference. And many times there's a great backlog depending upon which county you are in New York. And that means that your case could be sitting on the trial calendar for 6 months, 9 months, and sometimes even a year or maybe even more. In that instance, we actually have to wait until the court tells us to come in for a pretrial conference. And now you're thinking, okay, it's now been 6 months to a year. You now get called in, or your attorney gets called in to come in for a pretrial conference, and you're thinking the defense is going to come in with a boatload of money, and now they're going to want to settle this case, and your case will finally be done. Is that what happens? No, no, no. I'm sorry to disappoint you again. That's not what happens. Okay, what does happen? What happens now is that the judge will turn to all the parties and say, look, can this case be settled? And now, if the defense thinks that the case might have a chance at settlement, now the judge will have us come back a number of times to see if the defense is willing to make an offer, and if so, how much. And if the case cannot be settled, then the judge is going to assign us a trial date, and now we proceed to trial. So getting back to the question I raised at the very beginning, you want this case to be done and finished with at the very beginning. You have every expectation that this case should be open and closed, and there should be no hesitation to offer you a significant amount of money to compensate you for all of the injuries you suffered because of the doctors and the hospital staff's wrongdoing. Well, unfortunately, that's not how it works. The defense wants details. They want information. They want to go ahead and go through the process. And only after we get them to recognize and to understand that their doctor has to be accountable for his actions, assuming we can show that we are slightly more likely right than wrong than what we are claiming is true. In other words, that the doctor was careless, that he departed from the standard of care, and as a result of that carelessness, you suffered significant harm and injury, and that your injuries are, in fact, permanent. When we are able to show that, then having that settlement conversation turns out to be much easier than we anticipate. So why do I share this quick information with you? I share it with you to open your eyes and to help you understand how these types of cases work in New York. You know, I realize you're watching this video because you wanted to see the beautiful scenery. No, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.